There's something called a conditional green card. What is that? It's a 2-year green card that is given to immigrants who obtain their green card status through their marriage to a U.S. citizen, and that at the moment that they were approved, the marriage is less than 2 years old. And why do they get conditional green card? That's because it's a new relationship, and immigration wants to make sure that it's going to stick before they give permanent status to this immigrant. So what you have to do is file a removal of conditions on the green card before the card expires and demonstrate we're still married, we're still living together. It's an application that we can do by mail, and they're not super complicated. But I often get questions from people who have separated or divorced, or they're thinking about it and they're worried about their 2-year card and what they're going to do. There are lots of ways to protect a conditional permanent resident or someone with a 2-year green card, even if there's been a divorce or separation, but you've got to consult with an immigration lawyer to talk through your options and timing of how you're going to apply for a removal of the conditions. The typical way to get the permanent green card is to apply to remove the conditions together as a couple before the expiration of the 2-year green card. And you would attach new good faith marriage evidence. Here's our new lease contract. Here's our recent bank statements. Just evidence to show you're still living together in a valid marriage. That's simple. But what if you've separated or divorced? What happens with the 2-year green card holder? Well, there are ways to remove the conditions without the assistance of the spouse. The first is if there's been a divorce, you can demonstrate that this was a good faith marriage that ended in divorce. But obviously, this requires a final divorce decree, so the timing is important. Another way to do it is through extreme cruelty. Let's say the immigrant has been in a relationship with the U.S. citizen and there's been what feels like cruelty in the marriage, which can be physical abuse or emotional abuse. Well, that immigrant can talk about what they have suffered in their application and remove the conditions on their green card without the assistance or even the knowledge of their spouse. If they're still together, they can still file this type of application. The last way to do it is through something called extreme hardship. This is where the immigrant would show that they would suffer extreme hardship if they don't get the extension on the green card. In my experience, this is lesser used and recommended. We typically will only do a hardship application if there's like a danger if they return to their country. It's almost like an asylum case. But there's lots of ways to do it. We do these all the time in my office, and I'd be happy to talk to anyone who is considering separation or divorce, but they have a 2-year green card and they're worried about what it's going to mean for them. When someone has a green card, they either have a 2-year green card or a 10-year green card. The 2-year green card is the conditional green card for people who have been married to U.S. citizens for less than 2 years. As they function, this person has every right that a permanent resident has. This means they can still travel, they can still work, they can do all of the things that a 10-year green card holder can do. It's just that they have to remove the conditions before the expiration of their 2-year card. Whereas a permanent resident who already has a 10-year card doesn't have to do anything to maintain or extend their status. They do have to renew the card every 10 years, but their permanent resident status doesn't change.